Okay, so last week we talked about the nitty-gritty of like contracts, and it was really the first time we were going into what we're going to be spending the next few weeks on, the specifics of contracts. So we talked a lot about the 4 basic requirements in a contract, and last week we talked about mutual assent. Today, we're going to cover the other 3 elements that are required to have a most basic contract, which is consideration, legality, and capacity. So the stuff that I say today, right now is going to sound familiar to you because it's going to be a little bit of what we spoke about last week, and it's just going to be a little bit more detail. Do not be fooled, by the way, by some of the repetitiveness of stuff, because your exam, your second exam, in accordance to the syllabus, is in October 21st. So you'll have another couple of weeks and it's going to be there. It's less information, but I'm going to be asking more detailed questions. So make sure that you're not just listening to the things I'm saying, but actually like understanding the material. And always, if you have a question, just, stop me. And it's better to do it by voice, like just say, I have a question. Okay, so we're going to go on to consideration. And as we spoke about last week, consideration it has 2 elements in it. It's the legal sufficiency and a bargained for exchange. And what does that mean? What does legal sufficiency mean? It means something that has to have value in the eyes of the law. And it doesn't matter what the value that's attributable to this particular item is, but something with value, okay? Because that's why you're buying or selling it. Whenever we're talking about contracts, we're talking about that exchange of goods, right? That exchange of property, personal property. It's not gifting something, right? So whatever it is that you're buying or selling has to have some kind of value to it. And so that is that consideration element. And so there also has to be a bargain for exchange. If I just give you something and you're just taking it as it is, well, maybe there was no back and forth. You want to have a little back and forth to show that it's something that was thought about, that it was considered, and both parties knew and understood what was going on. I'm not going to get into the detail with you as far as legal jargon as the promisor, promisee, but just understand that there has to be a legal detriment and a legal benefit in order to have the element of consideration actually met. So your legal benefit is when you're getting something that you don't have an obligation or a right to actually get, right? And a legal detriment is there's no obligation on the other side to do so. So we start out with 2 people meeting each other, and they're going to be buying and selling a particular pen. Neither one has an obligation to buy and or sell this particular pen, right? Nobody's forcing them to do it, but it's something that they want to do. And so if I sell you my pen, you get the benefit of a pen. This should sound familiar. We did this last week, right? And what am I getting in return? I'm getting money. You were not obligated to give me money unless I gave you that pen. So there is a benefit or a detriment. I'm losing a pen, but I'm gaining money, and vice versa to you. The value of the items doesn't necessarily need to be market value or anything like that, because when we talk about antiques and we talk about demand for certain things, it's really up to the person who's buying it to set a value. How much are you willing to pay for this particular item? I could see something in a store, an antique store, that maybe is worth $50, but it reminds me of my grandmother's blah, 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 and I have to have it, and I'm actually willing to pay a lot more than that. Why? Because maybe I'm attributing sentimental value to it. And so that sentimental value means more to me than just the face value. So the court's not going to say, well, you didn't have to pay $100, you could have just paid $50. I understood the price and I was willing to pay more to get this particular item. Look at auctions, for instance. When you go to an auction, a starting bid of X can be in an item, and that price can go up based on how much people are willing to pay, right? So the value itself may not just be the price tag on something, may not be the market value, because when there is a need, the price will just generally go up. And as long as you understand what that item is and you're willing to pay that amount, then a court, it's not going to come in and say, well, you didn't have to pay that amount or you paid too much, because it's something that you're doing voluntarily, right? It's a benefit that you're getting and nobody's forcing you to do it. We talked a little bit last week about unilateral contracts and bilateral contracts. And again, when you look at a unilateral contract, you can see, does somebody have a legal duty to act, and or is there a legal benefit? So if A promises to paint B's house, B has to what? If A promises to paint B's house, what does A have to do?
B has to pay for the work.
Right. And B only has to pay for the work when what happens?
I guess when it's completed.
That's right, when it's completed, okay? When the house is actually painted. Now, there is a school of thought that says, well, what happens if A says, I promise to paint your house? And then, I basically, the unilateral contract is, the one person promising, and then when the action is complete, that's when they get paid. What if the action is 90% complete, and then somehow the action then stops? Doesn't matter who's stopping it, Does B is then be obligated to pay if 90% of the action was complete?
I would guess that it's a pro rata portion. At least that's how contract law for contractors works in New York.
Okay. Well, the answer is actually, it just depends. It depends on
Yeah,
the
that's true. If I
situation,
have
right?
it spelled out in my contract, I can
Exactly.
correct. Yeah.
It depends on what caused that stopping of the action to happen. Did B suddenly say to A, you know what, you're doing an awful job, I don't want you to continue? And so did B then terminate the contract? And then A is going to say, well, I already did 90%, you're stopping me at 90%, I want 90% of the payment, or I want 100% of the payment. So it depends on, the circumstances that are going to dictate then whether or not money is going to be exchanged. It's not like it was, I didn't say it was 50% that was complete. It wasn't 10%. It was a substantial performance of the obligation that had to be completed was in fact completed. And then at that 10%, is B just doing this to be a hard ass so they don't have to pay and try to get out of the contract completely? Possible. Why are they waiting until 90% of the job is finished, right? It's like you complaining that the food is not good at a restaurant after you've eaten 90% of it. Well, why didn't you say something when you first got it? Okay, so when we look at unilateral contracts, because it depends on the action being performed, not the promise to actually complete an action, then you have an issue as to whether or not consideration is there. Is there a legal detriment? Is there a legal benefit? When we talk about bilateral contracts, when both sides are simply promising to complete an action, well, both sides are, they have the legal sufficiency there, right? Each side is promising to do something for the other. Each side is going to be the promisor and the promisee at one point. Again, all this stuff was really more listening. I didn't tell you to write anything down, but it's stuff that I want you to understand. What you still have to know, as I mentioned last week, you must know. This is a write it down. You wrote it down last week, write it down again. Again, the 4 elements of contracts, right? So we talked about mutual assent, consideration, legality of the object, and capacity. I want you to memorize those 4, okay? When we talk about illusory promises, this is something I want you to write down or put a note to yourself to know this well. An illusory promise is not even a promise at all. It's not really a real promise. So when you say or make an offer that you're going to sell as many widgets as possible, it's not a definitive thing. It's no end. It's not bound to do anything. There's no legal detriment. There's no legal benefit because there's no beginning, there's no end, right? There's anything that has words like wishing, hoping, desire, right? Those are not binding. Those are not definitive terms of a contract. Those are illusory promises. And if it's an illusory promise, it's not a promise. Therefore, it's not a contract. What did we say before about some promises and contracts? What was that little thing I told you guys last week? Anyone? Anyone? Some promises, all promises. Does that sound familiar? Okay. All contracts are promises. All contracts are promises, but not all promises are contracts. And an illusory promise, that is not a contract because it's not even a promise. So the term is a little bit of, it's a little misleading because an illusory promise, I hope to do the best I can in this class, professor. That way you can give me an A. Okay, that's great. You can hope and wish and desire that as much as you want, but unless you earn it, you're not getting it. So it's not a promise. It doesn't mean anything. It's just fluff. It's fluff. Like yesterday's debate, there was a lot of fluff in there, okay? So you want to keep that in mind. You want to know that an illusory promise is not a promise at all, and therefore it's not a contract and it's not binding. Okay, next thing I want you to know is output contract. What is an output contract? This was in your reading for today. So this all should not be like brand new, like, oh my God, what's she talking about? Because the only things I give you are to read and come to class prepared. So what is an output contract? Anyone?
It's a type of agreement that basically the seller of any product agrees to sell it to the purchaser, I guess.
A particular purchaser, right?
The entire
Right.
line or the entire production.
Exactly, exactly. It's an agreement from a seller that says, I will sell my entire production to you, one particular person. So an output contract is a seller saying everything I produce, I'm going to give you. Like, let's say a farmer has tomatoes or corn and they enter into an output contract with a particular store. They're basically telling this store, everything I produce, I'm going to sell to you. Now, think about it. This is now not just, this is not something to memorize, but think about why that is a good thing or why is that a bad thing?
No, it's a good thing because they already get the market for the product, so they don't have to think
Yeah.
about the supply chain and how they're gonna sell their stuff. So even they do that in the beginning of the season before they start. If it's a farm in this case, veggie store.
Yeah, I mean, it's just you have a particular, you don't have to worry about who's going to sell my products, who might, how much advertising do I have to do? What if I have too much? What if I have a surplus? It encourages you to produce more because you have somebody who's willing to buy it. Now, what is a requirement contract? What is a requirement contract?
It is a supplier to buy with all of his requirements of certain goods.
Yeah, can you give me an example of it? Like I gave an example, give me an example of a requirements contract. It's like the opposite, right? It's just basically like the purchaser saying, I'm going to purchase from you, right? all the material that I need, I'm gonna get from you.
It's basically saying they'll supply as much as needed.
Okay, that's a good way to put it. I want you guys to know the output contract, okay? If you're gonna know and understand something, if there was one of the two I want you to know the output contract, okay? What about an exclusive dealing contract? What's an exclusive dealing contract?
Where you're only going to deal with that party, basically.
Yeah. Yeah,
Yeah, like
it's
exclusive distribution, something like
exactly
that.
exclusive distribution. You see it all the time. You might just not realize it. Back in the day, when we used to actually attend the College of Staten Island, if you were thirsty and you went to a vending machine, tell me the drinks that you would see in the vending machine, if you remember.
I believe it was all Pepsi products, right?
All Pepsi products. Did you ever see Coke on campus?
No.
Did anybody? Unless like somebody brought it with them. It appears that CSI had an exclusive dealing contract with Pepsi, which means that they're only going to be selling Pepsi products. Sometimes when you go to certain stores, they're only going to have one particular brand because that's the deal or that's the agreement they entered into with one another. When a new phone comes out, sometimes T-Mobile or whatever will say, you know, we're the exclusive seller of the, you know, iPhone 100, right? The only one that we're going to be selling it for X period of time. So an exclusive dealing contract is exactly what it is. It's an exclusive deal between two parties that allows one party to be the only one to sell that particular product, and it could be for just a specific period of time. Okay, I want you to also know exclusive dealing contract. This now is a listening. I'm seeing there's a bunch of comments here. Let me see if there's anything here. Let's just see. La-di-da-di-da. Okay. Okay, blah, blah, blah. Contract. Okay, hold on. Okay, Wendy. Okay, Wendy's Burger King. Yeah, they probably have only like one, also like one particular type of drink. Shows like HBO. Yeah, you're only going to be able to watch certain shows on certain networks, right? You can't watch. I used to watch, what was that show called? I don't have it in memory anymore. What was it? It was a big, it doesn't matter, but it was only on like, I think Showtime, and it was a big hit a couple of years ago, but I can't remember anything. My brain doesn't function anymore. But yeah, there's exclusive dealing contracts in all different fields. And now I hope that you're aware of it. Try to pick up on it. Because it's just interesting because now you know what that is. Okay, this is a listening, not a writing, a modification of a pre-existing contract. So back in the day, prior to a change in the law, if you had a contract with a person or individual or a company to do X, Y, and Z, if you were going to modify that contract in any way, you had to have new consideration. And that means you'd have to like kind of buy or sell something else or maybe exchange funds again, right? But under the UCC, the Uniform Commercial Code, you actually don't need new consideration to just modify a contract that's already in existence. And what does that mean? If you were going to be, you know, buying steel from a company that manufactures it because you're a builder and you need it, and you agree to, you know, like, I don't know, $5 a pound or something, and then there was a steel shortage and they wanted to raise the price, but you were still okay with the price being raised because you were able to at least get it so you can finish your project. You would just modify the contract accordingly without having to negotiate anything else, or without having to pay any money or exchange any funds or anything like that. Prior to that modification in the UCC, you would have had to do that. But again, that's just like a, you know, fun-filled fact, really. Substituted contracts, you know, sometimes if you have a contract between two people, you have, this is a listening, not a writing, you can bring in a third party or a third element into it depending on whether or not it's needed. I see the substitution element in law a lot because sometimes you're suing one party, and then, you know, as discovery happens, you realize that you want to bring in a third party into it. So it's you're bringing into like a third element or a third player kind of into the deal, so you can basically sue everybody. Sue more, you know, the more the merrier, right? This thing I want you to know. This is called the settlement of an undisputed debt. This is a practical thing, and that's why I want you to know it. So the concept of settlement of an undisputed debt is as follows. You owe me $100 because I lent you $100. So I lent it to you today, and you know, a week from now, you give me $40. So how much do you owe me? Not a trick question.
$40.
Nope. You gave me 40. So how much do you owe me?
60.
$60, right? So I gave you 100, you gave me back 40, and now you owe me 60. When you give me the $40, I tell you, don't worry about the rest. Do you actually owe me the rest?
No.
You actually still do. You know why? Because I gave you 100. I could still come back and say that $60 you owe me just because I said, don't worry about it. There was no bargained for exchanged. I didn't get anything back from it. It's like, am I now giving you a gift? How is that going to be proven? In order for you to actually safeguard the point that I no longer should be getting that $60 back from you, what you should do is you should give me something of value. That way, quote unquote, it's an equal exchange. That way we've actually contracted that part out. That way we've negotiated that part out. So you owe me $60, you know, and then I tell you don't worry about it. You should say, you know what? Thank you so much. Let me give you something to show my appreciation. Here's a pen. If I accept that, that means I took that pen in exchange for that $60. Yeah, somebody, if you basically pay for dinner, you pay for dinner next time. Kind of something like that. I mean, dinner, you might say that it's a again, it's a gift, but do you get the idea? Do you get the concept of why it's important to kind of put something in place of that 60? If you have it in writing that, okay, I absolve you of that debt, then that's fine. But if you don't have that in writing, a good way to do it is just to give me something in exchange for that 60. That way it's a bargained for exchanged. That way that consideration aspect is completed. Because what is, if you think about a loan, it's a contract, right? It's a contract that says, I am going to give you $100 today because you need it. So therefore, I have lost $100. You've gained $100. If we're friends, you give me the $100 back, and I don't ask for anything like interest or anything like that. Or maybe you buy me lunch or something because I gave you $100 in your time of need. But how do we have that bargain for exchange? How do we have that consideration? How do we make sure that that contract is actually carried out to its fullest extent? I need to be compensated for that $60, unless we're going to try to show that it's a gift, in fact, a gift. Let me see here what you guys are writing. Okay. If you pay for now, okay. Like a vacation, wedding, paying to come and not need a gift. Yeah, if you come, you don't have to buy, buy. It could be. But I would say that it's a little bit different only because like you're going for, you're not obligated to go to the wedding. You could just be like, no, thank you. I don't want to, spend $20,000 to go to your destination wedding, wherever it is. But maybe something like that. I mean, just as long as you get the idea of the importance of that $60, it's a settlement of an undisputed debt. Okay, so that's that principle. Okay, this is just a note, a birthday gift. This is a bargain for exchanged. A birthday gift has no consideration because there's nothing given in return, right? When you give a gift to somebody, you're not getting anything in return. it's a gift, right? There's no bargain for exchange, there's no consideration, there's no contractual obligation. I mean, does good manners or good whatever juju say, you know, if I give you a gift of X value, you should give me something like that in return? You know, it depends on what you have. Maybe a gift is more meaningful and more personalized. It could be cheaper or it could be more money. But just, you know, understand the difference between a gift and between a contractual obligation, okay? This is the next concept. This is in your textbook again in the syllabus. Past consideration is not consideration. So when you do something for someone and then they say, oh, I'll pay you back for it, it doesn't work like that because you already did it without needing any consideration. It's like when I do you a favor, but you didn't actually ask me to do it, then they say, okay, I'll get you back. It's like that dinner example. Past consideration is not really consideration because I did it without the expectation of getting anything in return. So it doesn't, you can't say, well, I did it for you, so you can do it for me. Are you all with me so far? Anyone?
Yes,
Okay.
all good.
Okay. All right, great. Okay, excellent. Third-party consideration. Third-party consideration. You can negotiate with somebody and involve the third party, right? So you can enter into a contract, A and B can enter into a contract with one another and potentially involve C as a contract. And maybe they'll also have contractual obligations. So let's say you are in college, let's say, and you live with your parents and you need to borrow money for college and you need to take out a bank loan. You may be able to negotiate with the bank, but who's the bank going to try to loop in and get to be part of this agreement?
The parents as
The
a security
parent. Yep,
deposit. Yeah.
exactly. The parents are going to be looped in. Why? Because the parents can pay and can handle the financial obligations in case you're not. I have co-signed many loans for my siblings when they were growing up for college, right? Because at that time they could not, you know, take out the money. They didn't have the credit. So I co-signed with them and I told them, I will take your first child if you don't pay and make sure that you're on top of these things because it's going to affect me. Right? So it's two parties getting into an agreement with one another, but there's certainly a potential for including a third party. Okay. Let me see here. What else? Don't worry about this. Firm offer. Okay. This is just the listening one, and then we're going to conclude chapter 12 and move on to 13. A firm offer is typically done when it's an agreement between merchants. So two people or two entities that buy and sell with one another, not just the regular person. And so when they are buying and selling, like even an offer should be in writing between them, even if there's no consideration, because typically they're doing business with one another. And so even if there's no consideration, they have a period of a few months where they can make that consideration happen or, you know, put down a down payment. Sometimes deals and contracts with merchants, and when I say merchants, it's businesses, it's a little bit different than with regular people because they're doing business on a regular basis. So it's not like they have to pay right away for the stuff. There are some agreements that dictate, you know what, you give me the product. If I'm a deli, and I'm buying bread from you so I can sell it to my customers. Perhaps the deal that you and I have is you're going to give me the product. I'm not going to pay you anything. We're going to have some kind of delay. That way I can sell the product, make money from my customers, and then I can pay you this invoice. So again, it depends on the relationships between entities. It depends on whether or not they're merchants, business people, that they can get the consideration right away, the payment right away, or whether or not there could be a lapse in time. Okay, any questions on this stuff before I go on to chapter 13, illegal bargains? I'm trying to make this stuff as simple as possible so you guys can get it. All right, so I'm going to move on. And we only have chapter 13 and 14 today, and then we'll be finished. Okay, so chapter 13, I love this chapter, illegal bargains. So illegal bargains, right? You can't enter into a contract over something illegal, right? You can't. So I gave you the example last week about, if I want somebody killed off and I hire a hitman. If you can't sue me and I can't sue you if that deal somehow breaks, because I should not be hiring people to kill other people, right? That's illegal. You're not supposed to do that. What other activities are considered illegal that obviously you can't hire people for? I mean, you could come up with like a ton of things that you're not supposed to do, right? So you just, let's say, I'm sorry, I do apologize if I gave you this example last week, but let's say you wanted to buy drugs from someone, and I don't know, cocaine is the powder one, I think. Yeah, cocaine is powder, crack is hard. So let's say you wanted to buy, I don't know, a pound of cocaine, and you're paying whatever the going rate is. Let's say it's $100. And so you give somebody $100 for this pound of cocaine, they give it to you, and now you take it home and it turns out to be powdered sugar. Now sugar is actually legal, right? It is a legal substance. You can buy sugar. You can buy it in ShopRite. You can buy it in Pathmark. You can buy it in Stop and Shop. Now, you have now purchased 1 pound of sugar. Is there a contract between you and this person? Did you actually, in fact, enter into a legal contract?
You did not, because
Why?
the purpose of the contract was to purchase an illegal item. Whether that
Exactly.
item ended up being legal or not is really moot.
Exactly. Excellent. That's right. The contract itself, the meeting of the minds, was over an illegal substance. So just because you got something legal does then not give you the oomph or the standing to actually sue in a court of law, because what you actually contracted over was something that was still illegal that you should not have done. Okay. Now, gambling. Is gambling legal?
I was going to ask you that actually.
It depends. It
Depends
totally
on the
depends.
state, country. There's
It
so
depends
many
on the
things.
type of gambling. It depends on whether it's a gambling regulated by the state, right? Now you buy scratch-offs. Scratch-offs are legal, right? You can go into any deli and buy a scratch-off. Nobody's going to arrest you for buying a scratch-off. However, if you are entering into a pool of, I don't know, whatever sport is pending now or not pending, right? I think football is a big one. And, people break legs and they lose lives over this stuff. Is that a legal form of gambling? It also depends. So I'm not even going to have you answer that one. It also depends. So most of the time it's not legal. So if you bought, those like squares that they have for the football thing, and let's say you buy a square and you actually won and you were supposed to get, let's say, $10,000, and the person that was collecting the money is giving you the runaround and they're not paying you, can you go to court and sue them because this person didn't pay you the $10,000?
I would
No,
almost say it depends, because if it's a pool organized and the person doesn't take a profit, it's actually legal.
Exactly. If the person doesn't take a profit, it is in fact legal. Now, my understanding of the world as it works, if you don't pay that person a percentage and you do in fact win, you're never going to be asked, number one, to play again. It's like an unspoken rule. So, do you take the chance and go to court and say that so and so organized the pool, all these people were participants, and then try to collect your money that way? Or are you going to find some other way to try to collect the money, right? So again, it's very fact specific, but do know, to be on the safe side, that gambling is legal when it's organized by the state. And if it's not organized by the state and you are owed money, you may have a hard time collecting any winnings that you did in fact get. Okay? Okay, I'm going to move right along. So, licensing statutes. A licensing statute is a statute basically that mandates some professions get a license before they can actually operate. So if you go to a nail salon, you see those certificates on the wall. Those people have licenses to operate. Plumbers, accountants. What's great about somebody with a license from the state, from a legal perspective?
They're
They can have their own
regulated.
business.
They're regulated, but what else? What would I say? What would I think is great about somebody that's licensed?
Credentialed.
Yeah, that too, that too. But you can sue them.
I was
You
going to
can
say that.
sue them. You can sue them if they don't do something right, like unfortunately. So when you hire somebody to do work for you, yeah, you may be paying more for somebody with a license, but also know that if they don't do a good job or they don't fulfill their end of the contract, you can sue them. Are you going to be able to sue somebody who does not have a license for which their job requires or does have some kind of licensing? Well, again,
Nope.
it depends. If you try, the judge will probably say, well, you should have hired somebody with a license. Why are you going to somebody that doesn't have a license to do this and expect good work to be done? There was this thing that I watched many years ago, and it was people who were getting cosmetic surgery from this woman who worked out in the basement. I don't remember where it was, which state it was, but they were getting implants. And it was discovered that the product that she was using as implant actually had cement in it. And there was, I think people got sick and somebody died as a result of it. Now, was this person licensed to be performing these types of procedures? Absolutely not. Did people know that and still go to her? Yes, because she was cheaper than a lot of other people. Because if you go to somebody with a license, they're going to charge more money for it. So people want to save money, so they go to somebody without a license. But again, you don't know what's happening. There's no regulation. You don't know what they're putting, and especially if you're going to do something to your body, go to somebody with a license. So again, licensing statutes require that the state approves it. They're mostly regulatory in nature to make sure that there's a standard. There's a particular kind of standard that's being upheld. And when we talk about, regulatory licenses, it's supposed to protect the public, right, from unqualified practitioners, like the example that I gave you. Okay, so those are the licensing.
And my understanding of the licensing is if the licensing is really just kind of like a tax, not actually a credential, then people that aren't licensed can be sued. Am I understanding that correctly?
The people that are not licensed can be sued. So like somebody that just does, maybe like does
like, let's say, okay, so New York City has a license for everything. You need
correct.
a license to sell water ice, whatever.
Right.
But that license, you don't really need any qualifications
Correct.
to do it. All you have to do is pay for the license.
Correct.
My understanding of the book was that when a license is really something that you have to just pay for, it doesn't make that profession the same as like a professional
Correct. That's
occupation,
correct.
like a doctor or a lawyer. So somebody that isn't licensed could participate in it and still
Correct. Be sued, be held responsible.
Yes.
Yes,
there
that's
we go.
correct.
Yeah.
Yes, very good. Very good way to put it, actually. Excellent. Okay, let me see here. Yes, because when you have the revenue like aspect, it's not to protect the public, it's just really to simply raise revenue. So there's no, it's just a way to raise money. So that's very good. I'm gonna just see here my syllabus, whether or not I had this one particular case. I do not, so I'm not gonna talk about it. Okay. Gambling, we talked about. Okay, usury statutes. This is actually something I know more than most people because I worked in this field for maybe 2 years. Usury statutes prevent a loan. It basically prevents loan sharks. So when you borrow X amount of dollars and you have to pay it back, there's usually interest. But an enormous amount of interest is considered usury. And so depending on the state that you're in, states will set a maximum interest that can be collected for loans. Now, when you go to somebody, again, that's like a loan shark and you borrow money from them, they're not going to sue you if they're charging you 50% interest. What are they going to do?
Break your kneecaps.
That's right. They're going to break your kneecaps. So again, it's illegal to charge 50% interest. So therefore, you would not even be able to sue, or they can't sue you because you've entered into an illegal contract. And the reason I tell you that I worked in this, I was not breaking legs and I was not giving out loans. Kind of I was. So I worked for this company, and it was a contingent loan funding company. And you may, depending on how old you are, this may sound familiar, it may not. Many years ago, there used to be loan commercials from this company called J.G. Wentworth. And it was like, get your money now. Why wait for a lawsuit to settle when you can get your money now? And there were these companies that were popping up where they would buy an interest in your lawsuit. So let's say you were suing, and lawsuits take a very long period of time to actually settle, to complete, to get your money. But you needed money now. You were hurt, you were injured, whatever. You could borrow money from this company, let's say $100,000. But what happens was when you actually settled, they would be getting a ridiculous amount of money. Now, how is it that they were not subject to the usury laws? I will tell you because I had to do research on this. It was because it was not an absolute guarantee that the money would be returned to them. It was contingent upon the success of a lawsuit. So if there was no guarantee and they could potentially lose their money, they were not subject to the usury laws. Let me tell you, we, the company I worked for, did not take cases where we did not feel you were going to get your money because we would ask for a lot of documentation. The attorneys I worked for, they would ask for the complaints, the lawsuit, the policy. They would ask for all this information. And then if it was good, then they would loan the money out. But it wasn't just like, hey, you're borrowing $100,000. There would be all these fees that were attached to it. The loan origination fee, the sub-application fee, and then the interest would be compounded. When people called to ask to borrow money, I'd always tell them, make sure you have no other choice but this. Talk to your friends, talk to your family, see if you can borrow money from anybody, because when you pay this back, it's going to be a ton of money. Some people, this was their only choice. There was now another branch where you could borrow money on settled cases, and the interest rate for that would be much, much lower. It would be about 2%. Why? Because it was definitive. It was going to happen. It was just a matter of time. So the usury laws, again, in order for it to be usury, it has to be returned, and it has to be a very high interest rate, and it varies from state to state. Okay, let me see here. I have this thing, sale business. Okay. Employment contracts and restrictive covenants. This is something I want you to know, and this is something that you will use in real life. I'm going to try and use my whiteboard. Let's see here. Okay. Any of you guys actually work in real life?
I do.
Okay, one person. Yes, two
I
people.
know. I own a few businesses actually.
Okay, excellent. So this is going to be now right up your alley. So I'm going to, how do I share my screen? Whiteboard. Okay, we went over this before. You all should be very proud because now I know how to use it. Okay, so you enter into a contract with a business, and they put as you're reading the contract, you see that there's a restrictive Covenant clause, which says if you leave, you cannot work for a competitor within 15 miles, a 15-mile radius. So, a 15-mile radius is actually what? A 30-mile.
30-mile diameter.
Now, how big is Staten Island?
13 by 8.
Thank you. I did not even know the numbers offhand, but I knew it was a lot smaller than this, right? So if you were to agree to a restrictive covenant that places a radius or a miles restriction on you, you actually, and let's say you were working on Staten Island here, right? You would not be able to work anywhere here and probably parts of New Jersey, probably parts of Manhattan, Brooklyn, right? Because you would be surpassing that area. Is it reasonable to consent to this type of restrictive covenant? Or is that something that you can fight?
I mean, you don't have to sign the contract. I don't
You
know that
don't
they
have
have
to.
to offer you the job, but
You can certainly try to negotiate it. Why? Because you live in Staten Island, or you live in a city where everything is in close proximity to itself. This is Staten Island, by the way. That's Brooklyn, and here's New Jersey. Okay? Now, let's say you lived in North Dakota. I'm gonna just make this as North Dakota. And if you lived here and they gave you that 15-mile radius, there's nobody else. Nobody. There's more, there's animals and barns and no people. The 15-mile radius in North Dakota or even upstate New York would perhaps be reasonable. But when you live in a metropolis, a city like this, and you have a restrictive covenant that restricts your livelihood, it's something that you can actually certainly negotiate. I'm a big fan of trying to negotiate any and all aspects of a contract, but certainly something like this. Now, there's also different types of restrictive covenants, like the one that prevents you from working for a competitor for an X period of time. So if you leave my workplace, you are not allowed to work for a competitor for 1 year. You are not allowed to do X, Y, and Z for a prescribed period of time. You're not allowed to solicit my clients or any clients that came from this firm. Those are all types of restrictive covenants. You have to make sure that you read that clause carefully, understand its implications before you sign away something that could prevent or hinder you gaining a livelihood. Okay? So this is something important for you to know in life. Okay? The restrictive covenants and employment contracts. Okay? I'm going to move on to the next thing unless questions. No. Okay. Corrupting public officials. Believe it or not, this is in your textbook. Do not corrupt government officials. What does that mean? Do not pay people bribes. That's bad. Do not pay somebody something so they can rule in your favor, so they can pass a law a certain way. Corrupting public officials is a no-no. Don't do it. Now, how does that actually play sometimes in real life? Because I'm making it very simple. What actually happens with politicians sometimes, or people running for office, especially now that this is a hot topic.
Well, they have huge donations, huge donors, right?
Exactly. Yeah. Now you see what's very interesting. So there are rules and regulations with how much somebody can donate, a person or a company. But there are these things, these packs, these groups, where they do not have the same restrictions as persons or companies, where they collect money and they donate it, and they're allowed to donate it. there are special interest groups where they can donate it to a particular candidate that fits their mantra or their ideas. I got a call for the first time in my life 2 weeks ago, and they asked me to donate to a particular candidate. And I was like, I already donated to this person. They're like, no, no, no. You can actually give us money, and we are not bound by any of these rules. That way we can advertise on behalf of this particular person, because we want to encourage people to vote for this person, because if this person in office, they're going to help our interest. And I said, look at that. How interesting. I learned something new. And I had always heard of this stuff, but then it's like when it hits home, it's like, ah, interesting. So again, corrupting public officials can be in the way of donating to a particular campaign with the expectation that something will happen, in your way. You should not do that. That's illegal. Don't do that. It's wrong. Okay? Good. That concludes chapter 13. We're going to move on to the last chapter for the evening, which is contractual capacity. Also a very fun chapter, I think. And it talks about the capacity, mental capacity that you need in order to enter into a contract. This stuff may sound familiar because we talked about it in wills, okay? When we talk about contractual capacity, two people who are entering into a contract must be of the same mental capacity. Not so much that they're as smart as one another, but they both have to know what they're doing in order to enter into a contract. So if you have somebody who is mentally incapacitated, they can't enter into a contract. We talked about that. This chapter kind of focuses a little bit more on minors and somebody who's under the age of 18 that enters into a contract with somebody for something. So a minor that's entering into a contract is voidable. It's voidable unless it's been ratified, and I'm going to explain what that is. See, minors, believe it or not, and they don't know this, they're in a very strong position to either enforce or void a contract. And why? Because certain contracts that they enter into are valid on its face. There's certain types, but a lot of other contracts can be voided at the option of the minor, not the other side. And a contract can only be ratified by a minor once he or she has attained the age of majority. What does ratification mean? When I say ratified, what does ratified mean? Ratified basically means that they kind of confirm what has happened. So ratification is, let's say you entered into a contract, but you can actually get out of it, but you take a substantial step to perform it, or a particular period of time passes where you don't undo it or try to invalidate it. By your inaction or action, taking a substantial step, you have in fact ratified it. You have now confirmed it. You have now put a seal of approval on it, if you will. There is no power to ratify if you're a minor, because ratification can only happen once you have reached the age of majority, and it has to happen through either you signing a particular entity, writing an email, or it could be even through implied conduct. Excuse me. There's a wonderful case that actually brings this theory to light, and it's the case of In Re Scoreboard. Who would like to tell us about In Re Scoreboard? Anyone? The case with Kobe Bryant. Anyone? Okay, so I'm not going to tell you about the case.
I can share the story. I don't know if I'm gonna be able to share the whole story, but
do the best you can.
Case for sure.
Save your classmates.
Yeah,
Otherwise, I wasn't going to talk about it, and I always test on this case. So tell us what you know.
Basically, what happened? Kobe Bryant was a 17-year-old kid, and instead of going to college and college basketball, he jumped straight to NBA. And in April, I think 1996, there was a company who is basically selling cards, sports cards, and other type of how you call it, like gifts or whatever you guys call it. I don't know what
Yeah,
exactly too.
like
So,
yeah.
and they approach him and they offer him a contract. So basically, they offered him, so they wanted him to sign, I think 15,000 cards. They were planning to have 2 events with him. So he's supposed to be there and sign cards and shirts, and they offered him $2 for each sign. And also they promised him $10,000, I think, for that contract, plus the $2 for each autograph. And but there was like a minimum quota of 7,500, I think, autographs. So basically, he could sign 7,500, at least 7,500 under that agreement, right? So later in that year, I think it was in the summer, his agent and his father, who was part of the negotiators, they made a counter offer, and they sent it to the company. In what's the name of it? In red, the score or something like that.
Yeah, scoreboard. Yeah.
So they made a few changes on the contract, and they send it to the company. So signed. They send the contract signed, right, to the company. But the company, instead of signing it and putting it in their records, I think they didn't sign it, and they just kept the contract the way it was, just signed from one of the sites. And in a year, he turned already 18, so he was an adult, not a minor anymore. So he spent like year and a half, I think, under that contract as a minor.
Right. Correct.
And so there were some issues in the company. So his agent basically realized that they're running late with the payments to other sports celebrities or stars, and they broke the contract. Basically, he stepped out of that contract, and the company, I think they filed for bankruptcy, right?
And they sold it to a different company. Yeah.
Yeah, and they basically notify them that they should pull out his name and face of any of the products that they offer before they step out of the contract.
Do you remember what happened when he turned 18? The deposit he made?
Yeah, he deposited that $10,000
Exactly.
for 4 days. What was it? 4 or 5 days before, after his birthday or something like that.
After his birthday, yeah.
After his birthday.
This whole case, really, the thing I want you to know is Kobe Bryant entered into a contract. He was supposed to sign all these things, and he was going to get this much money for signing this many balls and autographs and all that stuff. He was getting more famous. He wanted to negotiate the contract better because now he really could have gotten more money based on what he was doing. The problem is there was a contract. It was signed by one side, but it wasn't signed by the other. But he still continued to perform under the terms of the contract after he turned 18. And what was more so is he deposited a check from them for payment that his obligation, right? So when they were trying to say, oh, there's no contract, blah, 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 well, you confirmed, you ratified the contract after you turned 18 by continuing to perform your contractual obligations. And more so, you deposited a check of $10,000. So you can't then say, oh, I don't have a contract, I'm getting out of this contract, it's no good. No, because you ratified it. If he had tried to undo it, or he didn't accept a $10,000 check, then you could say, okay, he could have gotten out of that contract. But because it was after he turned 18 and he deposited that check and he continued to perform, he ratified that contract. Okay, so again, the thing I want you to know, the only thing I want you to know about this case is ratification of a contract after you turn 18. That a minor can only ratify a contract after you turn 18. Before that, you can get out of a contract that was entered into. I told you at the beginning of this that there are some instances where it doesn't matter what, the minor cannot get out of a contract. I'm going to tell you what those things are as soon as I give you the secret phrase for the evening. So it's the secret phrase for September 30th is as follows. My son loves to build Lego ships. My son loves to build Lego ships. One more time, the secret phrase. I'm going to also write it down. My son loves to build Lego ships. So that's probably a couple of phrases. You guys are like almost halfway there, I think, right? Once you get the 10, you can email me. I don't have the video on. You can email me your 10 phrases and I will gladly input a grade of 100 for your attendance grade for this class. Again, once you have 10, you can send it to me. If you only have 9 and that's the best you're going to do, you can send me those 9. I'll give you a grade of 90. You get 10 points for each one, okay? So resuming what we were saying, liability for necessaries. So if a minor enters into a contract, they will be held responsible if the contract is for food, shelter, medicine, or clothing, because those things are necessities, so they cannot get out of it. So again, food, shelter, medicine, and clothing. Food, shelter, medicine, and clothing. I did say the secret message. I'm going to say it again. Do not put it in the chat. Do not put it in the chat. So the secret message again, last time for the evening is, my son loves to play with Lego, or loves to build. Hold on. What's he doing? Hold on. That's why I have to write it down myself. My son loves to build Lego ships. My son loves to build Lego ships. Okay. So if you enter into a contract, with a minor over a car, can that be considered a necessity and try to hold them responsible for that vehicle? It's going to depend on the facts. If this is a 17-year-old that has emancipated himself or herself and they're buying a Toyota so they can get to and from work, it can be considered a necessity and they can be held responsible. What if they enter into a contract to buy or to lease a Ferrari? Can that be considered a necessity?
No, absolutely.
No, definitely not. So then if you are, I don't want to say dumb enough to lease a Ferrari to a 16 or 17-year-old, they go with that car left and right, put miles on it, and they're not paying, and then they drive it for a year, and then they give it back, you're screwed. They can get out of that, and you're not going to be able to hold them responsible. Why? Because you shouldn't have entered into a contract with a kid. Okay? So you can hold them responsible for necessities, but they can get out of non-necessity things before the age of 18, okay? Luxury
Wait,
item.
can you repeat that?
Sure. So if you enter into a contract with a minor, they will be held responsible if you entered into a contract for necessities, food, shelter, medicine, clothing, possibly transportation, depending on the circumstances. And so they won't be able to get out of the contract. They won't be able to void the contract if it's something of a necessity. However, if you enter into a contract with a minor over something that's not a necessity, like a Lamborghini, the minor can void the contract prior to reaching the age of 18 because they have that option as a minor. Make sense? Okay, I'm gonna move on because nobody's saying it doesn't. So okay. So that is that. Don't worry about torts with minors. That's fine. When we talk about, so now we're gonna talk about a little bit with also mental capacity, but now it's no longer minors, it's persons under guardianships. So we talked about a person who doesn't have the mental capacity to actually enter into a contract. A person who does not have the mental capacity to enter into a contract can only enter into a contract if there's a minor representing their interests. Otherwise, those contracts are void and there's no legal effect. So whenever we have a mental illness or a defect, the person who's under that disability does not understand the terms of the contract, so it cannot be a valid contract. Whenever you have two people that enter into a contract, just think of the basics. Both sides have to understand the type of agreement they're entering into. And so if somebody does not have that mental capacity or they have an impaired mental ability for some reason, they can get out of the contract because it's voidable. So if somebody was intoxicated, it's a voidable contract because once they come to, they realize they shouldn't have entered into that contract, and so they have the opportunity to actually get out of it. Sometimes maybe a court is less lenient if somebody voluntarily was intoxicated and entered into a contract. But again, basic contractual obligation is both sides, both parties have to know what they were entering into in order for a contract to be valid. But you also can't take your sweet time to invalidate this contract. It has to be prompt. It has to be within a reasonable period of time. Once you realize you would have had to take the necessary steps, not be like, oh, let me wait and see if the contract I entered into while I was all under the influence actually works out for me. No, like once you realize that you did not have the mental capacity, then you have to take the necessary steps in order to get out of it. So it's a voidable contract. Whereas if you enter into a contract with somebody that does not have the mental capacity to do so, that it's a void contract. Okay? Does anybody have? That's right. If you wait too long, that's ratification. Excellent. Excellent. Very good. Does anybody have any questions? Because that actually is my conclusion for the evening. Okay, so let's look at for next week. It's going to be chapters 15, 16, 17, and 18. And then the week after that, I guess we don't have class or something because it's, I don't know why. So it's maybe one of those whatever schedules. And then it's the week, the October 21st is when we have an exam. So I'll double check with CSI to make sure that I have the correct dates here. But so next week, look at the syllabus. All the information is there. And then we'll have an exam after that. Okay, as always, if you have any questions, just shoot me an email. We can always set up a time to chat. Probably easier to talk than, via phone than to do this. Okay?
All right.
All right, have a good night, everyone.
Have a good night, Professor.
Have a good night, Professor.
Good night.
Good night, Professor.
Good night.
Good night.
Good night.
Good night.
Good night.
Good night.